these, because I think that's been with us.
My pleasure.
All right, why don't we go ahead and get going so we can stay true to our time period. Diane, you ready?
Yes, I am. I am.
Good. Well, thank you and good afternoon. We appreciate you all joining us today for our webinar. This has obviously been an incredibly challenging week with the floods here and our community in the surrounding area, and our thoughts and prayers are continue to go out for all the families that have been affected in terms of their homes and the businesses. We're just so grateful there was no loss of life, and it's amazing to see how our community pulls together and the support that we've received. And so we know that we'll keep working together and building and helping one another. We debated continuing with our webinar today, but we thought that it was important. It's as people are trying to navigate the challenges and help one another with the flood, we also know that they're still trying to navigate what it means for COVID-19 and what it means to get businesses reopened and organizations reopened. And so we thought this was vital information. We're glad you can join us. Please let other people know. We'll be sharing this on our website and communicating this out so others can see this that couldn't understandably join us today. We want to make sure we're getting this information out. We had a great session last week on WorkShare, and so we'll continue to get that out and have other webinars just like this. So with that, I'm pleased to introduce our Vice President of Advocacy, Diane Middleton. And Diane will kind of run the discussion here, and we're so thrilled that Steve could join us as well. Thanks.
Okay, thank you, Tony. Good morning, everyone. Tony is exactly right. We realize there's another crisis going on this week, but we are resilient. And to that end, we felt it was important to provide our members with the tools that they need to deal with the first crisis. And so we're going to go on and we're going to hold this webinar. We will have it recorded and available for those folks who weren't able to join us today. So we are really excited and grateful this morning to be joined by Steve Palazzolo from Warner Norcross and Judd. He has been a presenter for us in the past, specifically for employment issues, and we're delighted that he's made himself available this morning to help our members walk through the steps of reopening and how you as a business can mitigate your risk as you take those steps so that you can resume business activities. I have the great honor of introducing Steve, and then we're going to let him get right into his presentation. Following his presentation, we'll have a little bit of Q&A. I have 4 questions that have already been submitted for Steve, so we will go through those, and then of course if time allows, we will ask those in attendance this morning to submit their questions. And there's a Q&A button at the bottom of your screen. You may have to run your cursor across it to find it, but hopefully you'll have the opportunity to submit some questions that way as well. So let's go ahead and get started. And as I said, I have the honor of introducing Steve Palazzolo. He counsels clients on employee issues, policy development, the National Labor Review Board, Americans with Disabilities Act, Family Medical Leave Act, the Fair Labor Standards Act, and international labor relations as well. His services extend to acquisitions, immigration, employee benefits, campaign finance, employee litigation, and civil rights. Steve represents numerous organizations in the automotive supply industry, agriculture, finance, food processing, hospitality, manufacturing, marketing, and service industries ranging from startup businesses to large Fortune 500 clients. He advises clients in the Midwest, United States, Asia, Europe, and South and Central America as well. He is a frequent speaker for industry organizations, including the Original Equipment Suppliers Association, the Society for Human Resource Management, and the Association of Corporate Counsel. Steve's valuable and broad expertise was earned through his unique work history. In fact, prior to law school, he was a shop floor supervisor in both union and non-union food processing plants. He spent 11 years as in-house counsel in labor and employment law and oversaw an HR department for a multi-billion-dollar multinational corporation with extensive manufacturing operations. Steve created the Warner Norcross Judd employment blog and is active on Twitter. And I know he is because I found him there this morning. Visit zoemichiganemploymentlaw.wnj.com and Twitter @zoemploymentlaw to stay informed and on the latest employment and labor law trends. And to sum it all up, I think it's fair to say we have exactly the right expert joining us this morning to help you learn how you can mitigate your risk as you reopen your businesses. So with all of that, Steve, I'm very pleased to turn it over to you.
Thank you very much. That's very flattering. And I don't think any of it's true anymore. For the last 12 weeks, all I've talked about is a virus. So let's just kind of jump in and start talking about where we are and what we've got going right now. And the new kind of the new lexicon in our life now, which is governor's executive order, something we never really had to deal with in the past, that we have to deal with extensively now, thanks to what's going on with this virus. So, as you know, the governor has issued a number of executive orders. We're up to 97 now. A number of them have been rescinded, but we are on number 97 for 2020. That's clearly a record for a Michigan governor. And those executive orders are giving us the guidelines, the boundaries, if you will, for what we can do as we start to come back to work. The most recent executive order, or two executive orders, which she issued, I think it was just yesterday, have opened up more of the economy. As the governor pointed out, she was going to open the economy up in phases, and she's done that. The Upper Peninsula and the Upper Lower Peninsula are now, broadly speaking, open. And I say that because, to me, the prime indicator here is, can I go to a restaurant or a bar? And if I can go to a restaurant or a bar, the economy is, generally speaking, back open. And if I can't, we still have a bit of ways to go. And I don't say that because I'm, a fan of bars, even though lately I am. But I say that because that's where people are the most likely to break all the rules, right? At a bar or a restaurant. So, there's two recent executive orders that are really important, 97 and 96. 96 just outlines the industries that can now be open. And that list of industries now includes, we've always had essential functions, essential industries. We've got outdoor work now. We've got construction that can be largely open. We've got manufacturing facilities that can be largely open. Research laboratories that can be largely open. Don't know if there's any of you out there. Retail stores can be sort of opened in certain areas. We've got offices now that can be reopened in under certain circumstances, and then restaurants and bars, again, in certain areas, and then outpatient healthcare facilities, including your doctor's office, your dentist's office, and vets, in case there's something wrong with your dog or cat. This new executive order is 13 pages long, and one of the things she keeps doing that's driving us nuts is, instead of just doing an amendment to the order that's already out there, she rewrites the whole order, and we've got to go read the stinking thing all over again and make sure there's no little tiny changes anywhere. And she has, from time to time, slipped a fast one in on us. So what I thought I'd do is, since we're using this as our guideline for how we reopen, and since what we want to do here is talk about how you can safely reopen and avoid liability. I want to touch on a couple of big, broad topics first, and then we're going to get into a little bit of what's required in this executive order, because the executive order is defining things that you're going to have to do that are largely unusual, okay? Here's the first thing you need to know. As you know, the federal government passed a bill, a couple of relief bills, one of which, I think it was the CARES Act, I've forgotten now, provided an additional $600 a week in unemployment benefits for anybody who was laid off and collecting state unemployment benefits because of COVID-19. And as a result of that move by the federal government, many of you now have employees who are sitting at home. Now that the weather's getting nicer, I know it's been tough for you guys up there, but at least down here, who are sitting at home and who can now go to the golf course and who are making more money sitting at home than they were making coming to work. And that's created a huge problem as we start to bring people back to work, all right? Because they don't want to come. They're making a lot of money sitting at home and they don't want to come back to work. So here's the first thing that you need to know. The governor, the Small Business Administration, the federal government, they haven't put this in writing anywhere yet, but a number of people, including the governor, have said, if you get called back to work and if you're otherwise healthy, you have to go back to work. You will jeopardize your unemployment if you don't. And now that's an interesting threat. And there are fraud provisions to the Michigan unemployment statute. And if an employee doesn't properly report their income, and if they don't properly report the fact that you've offered them suitable employment, those employees may jeopardize their unemployment. They may lose it. There's also fraud provisions that provide for penalties for employees who lie and continue to get benefits when they're not supposed to get benefits. And the employee can be charged up to 4 times the amount that they got in improper benefits. Now, here's the problem with that. The problem with that is the unemployment agency's fraud line is so completely overwhelmed with calls that they're basically not picking up the phone. But the one piece of ammunition that you have in your quiver as you start to call people back is you can say to them, hey, you're going to lose your unemployment benefits. Now, you can't promise that, but you can threaten it. And that may be true and it may not be true depending on how fast unemployment works. But that is the truth. If an employee is otherwise healthy and they don't come back to work when you call them back to work, technically they lose those unemployment benefits. And that's an opportunity for you to get people to come back to work. Now, there are a bunch of exceptions to this, all right? And I said, as you heard me say, if the employee is healthy and they don't come back to work, they'll lose their benefits. But there are a number of exceptions to this. Here's the one big one that's not. I'm otherwise healthy, but I don't want to come back to work because I'm afraid. All right, the governor has said in a couple of press conferences now, that's not a good enough reason to stay home. But there are some good reasons to stay home that the employee is entitled to stay home for. Number one is Executive Order 2020-36. Executive Order 2020-36 protects employees who want to, or who have to stay home because they have COVID, and it prohibits you from disciplining, discharging, or otherwise retaliating against an employee who stays home because of 2 specific reasons. Number one, they've either got a confirmed positive test for COVID-19 or they have the symptoms of COVID-19. They get to stay home for that, and they don't have to come back until they've met the CDC guidelines for coming back. Or number 2, they're taking care of somebody who's got a positive test or who has confirmed symptoms of COVID-19. In those 2 cases, that employee is protected and you can't make them come back to work. That doesn't necessarily mean you have to keep paying them, although you might have to under the FFCRA for those of you that have less than 500 employees, and I imagine that's a number of you. There might be some paid sick leave that those employees are entitled to, but you cannot terminate those employees until they have passed the quarantine period and they're ready to come back to work. Now, that order also says that if you're otherwise eligible to come back to work and you don't, you can be disciplined or discharged. But if you have the reasons contained in 2020-36, you can't discriminate against those employees. So if you haven't looked at that order, I would suggest you go look at it. You can find it. You can find all this stuff at michigan.gov. Okay, so that's issue number one. There's other things that you have to think about that I want to remind you of as people are starting to come back. What if I'm taking care of, well, we all know about the Expanded Family and Medical Leave Act for schools and healthcare provider, child care providers being closed, and the 6 other reasons in the Expanded Sick Leave Act that an employee can stay home. They're protected for those. If they have any of those, you can't make them come back, and the employee is protected there. But the other things you need to think about is if the employee, what about an employee who's immunocompromised? Are they protected? You notice when I talk about 2020-36 here, I didn't say, but I've got asthma and my doctor says I shouldn't come back to work. In that case, the employee is probably protected by the Family and Medical Leave Act if you've got 50 or more employees. And if you don't, they're protected by the Americans with Disabilities Act. And if they've got an actual quarantine order from a doctor, they're protected by the FFCRA. So again, you've got to be super careful about when you start disciplining, if you will, employees who haven't come or who won't come back to work. The other thing you have to think about is the Americans with Disabilities Act. An employee who's disabled under the Americans with Disabilities Act is entitled to reasonable accommodation, and a reasonable accommodation might be leave. So if a doctor is saying to an employee, hey, you've got one of these underlying comorbidity conditions that make you incredibly susceptible to COVID-19, and it makes it worse for you and you might die, and that employee's not entitled to FMLA either because you're not big enough or because they haven't been with you long enough, they may still be entitled to leave under the Americans with Disabilities Act. But in that case, you get to follow all the regular ADA interactive process, get a doctor slip kind of thing for the employee to prove that in fact they've got the underlying condition. So those are the things you need to start thinking about as employees refuse to come back to work. Don't forget there are other statutes out there that might protect these employees in addition to these executive orders that we can't forget about, like the FMLA, like the Michigan Persons with Disabilities Act, like the ADA, and the Michigan Paid Medical Leave Act, which went into effect about a year and a half ago now. So employees also get to have their leave under that. And don't forget under that, they get paid leave if a child's school is closed due to a public health emergency, which I think we can all agree this is. So those are the basic things I want you to remember and ways that you can get in trouble when you start to bring employees back. Now, I want to take a couple of minutes here and just talk about the governor's most recent executive order and all of the things that you need to have in place as you start to bring people back to work. And here's the first thing I want to remind you of. These new executive orders that as they open up parts of the economy, every single one of these executive orders says, promote remote work to the fullest extent possible. So these are not necessarily licenses for you to just say, okay, everybody's coming back to work on Monday. They might be, but they aren't necessarily. If you have people that can continue to remote work, that's one of the things you need to think about as we start to bring people back to work. Okay, so let's start with the executive order with 97, which is the one the governor issued just a day or two ago. And what does that order require you to have in place as you start to bring people back? The order is broken up into parts. One is a part for everybody in the state of Michigan who has in-person work going on. That doesn't matter whether you're manufacturing or an office or a dentist or critical infrastructure or any of that stuff. If you're going to have people in the office, in the plant, at work, you've got to, at a minimum, do the following things, okay? The first thing you have to do is you have to have what's called a preparedness and response plan. It is a written plan. It's got to be in place. I think you get 2 weeks now from the time you open back up. In the first order, you had to have it in place before you could bring people back. But now you have 2 weeks from the time you reopen that allows you to get this plan in place. These plans are somewhat complicated and a bit comprehensive. You can't just slap together a couple of lines on a piece of paper and say, here's my plan for opening back up. You actually have to follow OSHA's guidance on putting those plans in place. Now, where's OSHA's guidance? OSHA's guidance has been out there for a while. And you can find, if you go to cdc.gov, cdc.gov, and go to the guidance, the interim guidance for businesses and employers responding to coronavirus COVID 2019, you're going to find on the right-hand side of that page, you're going to find a little link, and that link will take you to the OSHA guidance. You should take a look at that if you haven't done that already. And that will explain to you the process that you have to go through to put these things in place. Now, if you don't want to do it yourself, we're happy to help you do it. So give us a call, but you do need to have a preparedness and response plan in place. And it has to be, according to this order, it has to be in place no later than June 1st, 2020, or within 2 weeks after you resume your in-person operations, whichever's later, all right? The other thing you need to do is you've got to designate a supervisor or a couple of supervisors who are in charge of the plan. And they have to be in the facility. One of those people has to be in the facility at all times when you have people in the facility working, okay? So that's the second thing you need to do. The third thing you need to do is you have to provide training to all of your employees that at a minimum covers the following 4 things. 1, workplace infection control practices. That sounds a lot more ominous than it really is. Really what we're talking about is wearing your mask, washing your hands, social distancing. That's the kind of stuff we're talking about here. It has to cover the proper use of PPE, personal protective equipment. It has to cover the steps the employee must take to notify the business or operation of any symptoms or a diagnosis. And it has to include, of course, because the government loves it when you don't do this, it has to include how your employees can turn you in if you do something wrong, all right? In other words, how to report an unsafe working condition. For those of you that don't want to do this training yourself, we got that for you too. So let us know. We have a little 13-minute video that goes through all this stuff that we can get you. All right. The next thing you have to do is you have to conduct daily entry screening, and you have to put a protocol in place for screening employees before they come into the facility. This can be done online or in person. It can be done manually. It can be done any way you want to do it, but it's got to be screening, and you've got to keep a record of it. And we're asking people 3 primary questions at this point. Number 1, in the last 48 hours, have you had any of the symptoms of COVID? And there's a list of the symptoms that we can get from the CDC. Number 2, in the last 14 days, have you had close contact with anybody who's had any of the symptoms of COVID? And number 3, have you traveled domestically or internationally? And those are basic in the last 14 days. And those are basically the questions that we're asking. Employees have to answer no to all those questions, or you can't let them in. Now, what about temperature screening? Should we be taking everybody's temperature? That's an interesting question. If you are a manufacturing operation under this executive order, the answer is yes, you must take everybody's temperature with a no-touch thermometer. That's in the executive order. For the other places, offices, doctor's offices, stuff like that, interestingly enough, it's not required. I don't know if that's an intentional oversight by the governor's office or an accidental oversight by the governor's office, but technically that's not in there. Now, I would recommend to you, and the CDC is recommending to you, that you take everybody's temperature before they come in, or at least make them take their own temperature before they come in, and certify that they do not have a fever of 100.4 or above, all right? The next thing you got to do is, while everybody is at work, you have to keep them socially distanced to the fullest extent you possibly can. And we all know what that means now. It's 6 feet apart. You also have to provide, and that's an important word, provide. You must make available non-medical grade face coverings for your employees. You can let employees wear homemade masks if you want. You guys can't see me, but I've got a nice little bandana around my neck here now. I'm not wearing it because I'm in my office alone and I'm completely socially distanced. But you have to provide non-medical grade face coverings. And you have to require those face coverings to be worn whenever employees are not able to maintain social distancing. That's 6 feet. All right, we're running out of time, so I'm gonna bop. You gotta have cleaning and disinfectant protocols in your response plan. You have to have special cleaning protocols for when you have a positive case. If you have a positive case at work, and hopefully you won't, you've got some notification requirements if you have a positive case in work. You've got some requirements for when you can let people come back. You got to follow the CDC guidelines now. That basically means 2 negative tests after you've had a positive test within a 24-hour period, or if you haven't had a test, it's 3 days without a fever, without Tylenol, 10 days since your first close contact with somebody who's had. The rules are in the CDC website. You got to have a response plan for people who get sick at work. So if they come to work and they aren't sick when they get there, but before they leave, they get sick, you got to have a plan for doing that and isolating them and getting them off the building. You have to restrict business travel to essential travel only. You have to encourage employees to use the PPE if they're on public transportation. So if you have employees that take the bus to work, you got to tell them, hey, wear your mask on the bus. And you have to continue, like I said, to promote remote work to the fullest extent possible. Now, what we're doing to make sure we comply with all of this, and by the way, then you have specific requirements for each of the individual industries that have opened up. In addition to those requirements, there's specific requirements. Some of them are duplicative, and some of them are not. They're special and they're different. There's obviously some individual rules for restaurants and bars, for example. Servers have to wear face masks. You have to keep tables 6 feet apart, stuff like that. You can find the governor's executive orders at michigan.gov. If you go click on that cute little coronavirus picture that they've got on the front, it'll take you to their coronavirus page, and you click on executive orders, it'll show you all the executive orders, even the ones that are restricted or rescinded. Or if you, like I said, if you want, you can have us or your lawyer, if you use another lawyer, help you put together this plan so that you've got the plan in place. This is going to be your guidebook going forward. And by the way, I don't think this is going to end anytime soon. The OSHA wanted a response plan for all employers when we had H1N1 back, whenever that was. This is going to be an ongoing requirement. It might not be COVID specific, but there will be an ongoing requirement from OSHA and MyOSHA that you have a preparedness and response plan for infectious diseases. So that's something, I know you think this is an awful lot of work for now, and hopefully this will be over soon, but this is something you're going to need, I think, going forward, even after we're through this particular issue. Now, it's 11:30, so Diane's got questions for me.
Thank you, Steve. So just a few things to keep in mind, right? Not much at all, just a few things to keep in mind. Oh my goodness. Hopefully this gives our attendees at least a taste of what they need to keep in mind. And I can certainly provide you all with a link to that executive order so you can take a look at that for yourself. With that, we do have some Q&As. I've got, this one is more a point of clarification. I think I heard Steve answer this one already. Steve, if an employee is 6 feet or more from a client or coworker, do they have to wear that mask or can they forego it?
They are not required to wear the mask if they can maintain social distancing. Now, there are some individual requirements in the executive order for individual industries. And one of those is if you are dealing with customers, you have to wear the mask. Okay, that's technically, even if you're not necessarily 6 feet away. I read a study the other day. I don't know if this is true or not, because the information we get on this changes every day. But the World Health Organization or the CDC or somebody, I can't remember who it was, said that wearing a face mask reduces transmission of this thing by up to 75%. If
Wow.
that turns out to be true, we're all going to be wearing masks for a long time.
Yes.
But if you are a manufacturer, for example, or look, I'm sitting in my office right now. I don't have my mask on. I'm in my office all by myself. All right. Technically, the executive order, except for those specific industries like maybe restaurants or customer, if you run a bank and you've got people coming up to the teller window, technically, if you can maintain social distancing, you do not have to wear the mask. But whenever you can't maintain social distancing, or there is a risk that you won't be able to, if I get up out of my office to go get a cup of coffee, which I can't do because the cafeteria is closed, I have to put my mask on because I might run into somebody in the hallway.
Okay, thank you. Thank you for that clarification. I have another question that came in through the chat module, and I'm going to ask this even though it's for specific business, because I actually received this a week ago and I was not able to answer with the information that was provided by the state at this time. But I'd really like to get Betsy some clarification on this. So I'm just going to read it verbatim. So Betsy owns a Pilates studio and class sizes are limited to 8, 4, and 2. These are by appointment only. She is installing a large canopy tent outside so that they can host their classes outdoors. Under the governor's current executive order, can she offer outdoor classes now, provided they are socially distanced? And then her second question is, she's planning to reopen on May 29th. She's wondering if she is interpreting the order correctly about that. Betsy, I'm not sure. I think we're going to hear more about those executive orders coming forward, but Steve may have some insight there. And then she's also asking about whether her classes are limited to 10 people.
Betsy, I hate to tell you this, but I don't think you can open your gym. And fitness facilities are not one of the industries that have been opened back up, even up north. I mean, restaurants and bars have, but not fitness facilities. I don't know how much trouble you'll be at if you put a tent outside and keep everybody 6 feet apart. But technically, I think under the executive order, you are a fitness facility or a gym, and I don't think you're able to open. Let's talk about that May 28th date. The reason everybody's shooting for May 29 is because the current executive orders expire on the 28th. So the view is that on the 29th, all bets are off and everybody's going to get to open back up and we can all go back to doing whatever we want to do. I wouldn't count on it if I were you. You can aim for that, but I wouldn't count on it. I think one of the things that has been abundantly clear, and I'm completely speculating here, but it's speculation based on what's going on here, is that and that might be true in some areas of the state, where by May 28th, everything is open and we're, back to, we want you to socially distance and wear a mask, but basically everything's back open, malls and gyms and everything. And there are some areas of the state where that's clearly, I don't think, going to be the case. If you're in Oakland or Macomb or Wayne County, it's going to be a while before life is back to normal. There's just too much of this there.
Yeah. Okay. Thank you for that clarification. And Betsy, I'm sorry, that probably wasn't the answer you were hoping to hear, but it is the correct answer.
I will say this, Betsy. Call your lawyer, talk it through with him. You can do some research, but based on what I've seen so far, sorry.
Okay. I have another question in the Q&A function, and folks, we probably have a little bit of time if you'd like to type a few more quick questions in there. Our viewer is looking for clarification on if a client comes into their organization, they're a human service organization, and refuses to wear a face covering for a non-medical reason, do they have the legal authority to ask them to leave?
Absolutely, 100%. Your facility is your facility, and you get to set the rules that you want to set. Now, that's a different question than do you have to turn them away? And you know, we're seeing some crazy stuff. I mean, people are fighting in stores over whether somebody's wearing a mask or not. We had one security guard in Flint be shot and killed already. It's ridiculous. But you have a right to control your premises. It's just like saying you can't carry a gun on our property. You have a right in Michigan to carry a gun, but I can prohibit you from bringing it onto my private property. You have a right not to wear a mask, I suppose, but I can make a rule that says if you don't, you can't come in.
Okay, thank you for that clarification. I have one other question here on my list, but we will probably have time to take another short question or two for those that are watching in the Q&A function at the bottom of your screen. And while we wait for those to get typed in, here's the question. A primary challenge right now for business owners is interpreting the protocol from multiple sources. So we've got the CDC, we've got the state, we've got the Treasury Department, et cetera, et cetera. And Steve, you talked a lot about the governor's orders. So can you just touch very briefly, which one should we follow? Which is the definitive source, or are there just multiple and we have to live with it?
Well, you know, we've all heard unprecedented and new normal and blah, blah, blah. This is certainly that. It's certainly confusing. So here's the basic rules. The governor's order, until a court in the state of Michigan says different, the governor's orders are in effect law, and you should follow the governor's orders. The CDC, those are guidelines. Okay, they're not. You can't get fined or go to jail if you don't follow the CDC guidelines, unless the governor says you have to follow the CDC guidelines, or the federal government passes a law saying you have to follow the CDC guidelines. So with respect to opening your business, the way we're approaching this is we're taking the OSHA framework for a preparedness and response plan, and we're wrapping the governor's executive orders into that framework, so you have in a single place a plan that you can follow that we believe will put you into compliance with the governor's orders. I mean, it's not like there's a law out there. The legislature hasn't gotten together and passed a law that says you have to wear face masks in public. The governor has done that in an executive order. At some point, these orders will expire, but at least for now, you know, I would start, if I were you, with the governor's orders. And the reason I say that is because as these things have evolved, she has gotten considerably more specific in what she wants done. And so the AG's office isn't going to show up at your door. The sheriff isn't going to show up at your door and say, where's your CDC plan? No, they're going to show up at your door and say, where's your OSHA preparedness and response plan that complies with the governor's order? That's what you should pay attention to. Now, I don't want you to ignore the CDC. I mean, they're smart people and they're doctors, right? But those are guidelines. Those aren't laws. So unless and until the governor says follow that, or the president says follow that, or Congress or somebody says follow that, those are guidelines. The governor's orders are laws.
Okay, thank you. I have two more quick questions here. So of course we all know now we're dealing with two crises, and sometimes they overlap. So the question here is, what about an organization that, it's a very small organization, about 5 employees, but they would like to go in to assess flood damage and potentially clean up. However, they are currently closed because they've been deemed a non-essential business. So what do you think about that? I think
you can go in and you can assess the damage. I think you have to do it with a minimum number of people. Don't forget this. From the very beginning of this process, from the very first governor's order, critical infrastructure people could continue to work, but also a group of people called basic minimum necessary people. And at the beginning, before you guys had a flood, that was people that were necessary to make sure the inventory didn't spoil, security people, you know, the basic minimum. I actually have a basic minimum letter. That's why I'm in the office today. Basic minimum people necessary to keep the operation running. We've got somebody here opening the mail, and we have since the very beginning of this. Because of the unusual nature of what you guys up in Midland are facing, and I don't mean to laugh, it's awful. And I've got a lot of clients up there, and I feel for all of you. I think you can call that a basic minimum function, and you can go in and assess that. Now, I will tell you this. You're supposed to designate the people in writing who are doing that. So send them an email saying, we're designating you as basic minimum. We want you to go in on Tuesday and assess the flood damage or whatever day it is. And also, don't have all 12 of your people go in. Just the people that are absolutely necessary to do it. And I think you can do that no problem.
Okay, thank you. And then I have the last question I have for you is a follow-up, and I think I know the answer, but I'm going to let it come from an attorney. You talked about businesses having the ultimate say when they have folks come into their facility with no masks. How about if those people come in, they're wearing a mask, but they won't submit to a temperature scan? What do you say about that?
Same thing. Don't come in. That's going to be the rule. Now, you don't want to lose clients or customers either. You got to be a little careful. So you might want to think about alternatives for servicing those folks. Easy for a bank, for example, you just go to the drive-up, right? But again, same rules apply. It's your property here. Customers aren't quote unquote employees. And even if they were, you can require them to submit to a temperature scan until at least this is over. It's your property.
Okay, that's what I expected. Thank you so much for confirming that. With that, we are just about to the end of our time today. Steve, I want to thank you very, very much for joining us today and arming our members with some of the guidelines and knowledge so that they can safely reopen their business and mitigate their list. Steve said it a couple of times, there's just a lot of information out there. The target keeps moving a little bit. We at the Midland Business Alliance will do the very best we can to keep our members updated with the latest information. So with all of that, again, thank you very much, Steve. And Tony, I'm going to bounce it back to you.
Great. Thanks, Diane. And Steve, thank you. That's invaluable information. We really appreciate you taking time to be with us today. And as I mentioned, we'll share this. We know a lot of folks who are planning on joining us are dealing with the specific challenges related to the flooding for themselves and for others. So we'll get this out. So please let people know, and we'll share that as well. And so with that, for those that are dealing with that, we're sending out information in terms of ways that people can contribute, ways that people can get help. So please look to our website, go to the City of Midland, United Way, Midland Area Community Foundation. A lot of, as we would expect in our community, people are doing amazing things to try and help one another. So be safe, and thanks for being with us today.